Together we put the first black woman on the United States Supreme Court. And I'm mildly prejudiced, but I think she's the brightest person on the court.
Justice Jackson?
So my biggest concern is that your view has the First Amendment hamstringing the government in significant ways in the most important time periods. I mean, what would you have the government do? I've heard you say a couple times that the government can post its own speech, but in my hypothetical, kids, this is not safe, don't do it, is not going to get it done. And so I guess some might say that the government actually has a duty to take steps to protect the citizens of this country, and you seem to be suggesting that that duty cannot manifest itself in the government encouraging or even pressuring platforms to take down harmful information. So can you help me? Because I'm really worried about that, because you've got the First Amendment operating in an environment of threatening circumstances from the government's perspective, and you're saying that the government can't interact with the source of those problems. But whether or not the government can do this is something I took up with Mr. Fletcher, depends on the application of our First Amendment jurisprudence, and there may be circumstances in which the government could prohibit certain speech on the internet or otherwise. I mean, do you disagree that we would have to apply strict scrutiny and determine whether or not there is a compelling interest and how the government has tailored its regulation?
Certainly, Your Honor. I think at the end of every First Amendment analysis, you'll have the strict scrutiny framework in which, in some national security hypos, for example, the government may well be able to demonstrate a compelling interest, may well be able to demonstrate.
All right. So not every situation in which the government engages in conduct that ultimately has some effect on on speech necessarily becomes a First Amendment violation, correct?
Maybe not necessarily, Your Honor. I guess the top line question I would ask is, has the government set out to abridge the freedom of speech? And in this case, you see that time and time again, because if you control
That's not the test for First Amendment violations.
Your Honor, this flows from the plain text of the First Amendment, right?
No, I understand, but we have a test for a determination of whether or not the First Amendment is actually violated. So in certain situations, the government can actually require that speech be suppressed if there's a compelling interest, right?
It can, Your Honor, and I guess what I would say is that the courts below never got to strict scrutiny because the government never raised this. This has never been litigated. The question in this case is whether at the front end the government itself has undertaken
action. Is the coercion, is the state action, right? That's the question in this case.
And I would urge the court to address the state action issue just like you addressed it in Bantam Books. Use that term 4 times in Bantam Books.
And could I just understand, because it seems like an extremely expansive argument, I must say.
Exchanged between the White House and other federal officials and Facebook in particular, but also some of the other platforms. And I see that the White House and federal officials are repeatedly saying that Facebook and the federal government should be partners. We're on the same team. Officials are demanding answers. I want an answer. I want it right away. When they're unhappy, they curse them out. There are regular meetings. There is constant pestering of Facebook and some of the other platforms, and they want to have regular meetings. And they suggest, they suggest rules that should be applied, and why don't you tell us everything that you're going to do so we can help you and we can look it over. And I thought, wow, I cannot imagine federal officials taking that approach to the print media, our representatives over there. If you did that to them, what do you think the reaction would be? And so I thought, the only reason why this is taking place is because the federal government has got Section 230 and antitrust in its pocket, and it's to mix my metaphors, and it's got these big clubs available to it, and so it's treating Facebook and these other platforms like they're subordinates. Would you do that to the New York Times or the Wall Street Journal or the Associated Press or any other big newspaper or wire service?
So there's a lot packed in there. I want to give you one very specific answer first, and then step back out to the broader context. So specifically, you mentioned demanding an answer right away and cursing them out. The only time that happens is in an email that's about the president's own Instagram account. It's not about moderating other people's
Okay,
content.
we'll put that aside. There's all the rest. Constant meetings, constant emails. We want answers. Right. We're partners. We're on the same team. Do you think that the print media regards themselves as being on the same team as the federal government, partners with the federal government?
So potentially in the context of an effort to get Americans vaccinated during a once-in-a-lifetime pandemic. And I really think that piece of context, it doesn't change the First Amendment principles, but it's relevant to how they apply here. And I think it's important to understand that at this time, this was a time when thousands of Americans were still dying every week, and there was a hope that getting everyone vaccinated could stop the pandemic. And there was a concern that Americans were getting their news about the vaccine from these platforms, and the platforms were promoting, not just posting, but promoting bad information.
I understand all that, and I know the objectives were good. But once again, they were also getting their news from the print media and the broadcast media and cable media, and I just can't imagine the federal government doing that to them. But maybe I'm naive. Maybe that goes on behind the scenes. I don't know. But it struck me as, wow, this is not what I understand the relationship to be. That's all.
But I do. I think this is important because I have the same reaction that you do, that these emails look unusual. I think the idea that there'd be back and forth between the government and the media isn't unusual at all. When the White House press secretary on July 16th is asked about this by the press at the time, what she says is, of course we talk to the platforms just the way we talk to all of you when we have concerns about what you're doing, when we have information that you might find helpful. Now, there's an intensity of the back and forth here, and there's an anger that I think is unusual, but the context for that, I think, is that these platforms were saying publicly, we want to help. We think we have a responsibility to give people accurate information and not bad information. And we're doing everything we can to meet that goal. That's where this language of partnership comes from. It's not just from the White House. It's these platforms, which are powerful, sophisticated entities, saying we're doing the best we can. And the anger, I think really most of the anger when you read the emails, and I appreciate that you have because I think you have to look at them in context, the anger is when the officials think that the platforms are not being transparent about the scope of the problem or aren't giving the information that's available.
That you have to admit that there are certain circumstances in which the government can provide information, encourage the platforms to take it down, tell them to take it down. I mean, what about the hypo of someone posting classified information? They say, it's my free speech right. I believe that I got access to this information and I want to post it. Are you suggesting that the government couldn't say to the platforms, we need to take that down?
No, Your Honor, because I think that would be a great example where strict scrutiny would cut in the government's favor.
All right. So what do we do then in a situation in which, I mean, I suppose in this case we're asking, the government's point is we didn't coerce, and I appreciate, the debate about that. But you just seem to suggest that as a blanket matter, the government doesn't have the ability to, encourage or require this kind of censorship, and I don't know that that's the case.
So, Your Honor, I guess this goes to the bully pulpit as well. As I understand it, the bully pulpit has never been used to target the object of suppressing a third-party speech. You can use it to coerce behavior, you can use it to coerce companies to take certain actions, but when the government is identifying a specific viewpoint and specific content that it wishes to wholly eliminate from public discourse, that's, I think, when the First Amendment problem arises. And so I guess I'm struggling to find an example in the court's cases or in history where the court or anybody else has said the government, by virtue of being the government, can use its power to pressure speech intermediaries to eliminate entire viewpoints and content from the public discourse. And I think, that's Your Honor.
Can I give you a hypothetical?
Sure.
Suppose someone started posting about a new teen challenge that involved teens jumping out of windows at increasing elevations. This is the challenge. And kids all over the country start doing this. There's an epidemic. Children are seriously injuring or even killing themselves in situations. Is it your view that the government authorities could not declare those circumstances a public emergency and encourage social media platforms to take down the information that is instigating this problem?
Your Honor, the government absolutely can use the pulpit to say publicly, here's what we recognize to be a public health issue, emergency. obviously extremely terrible, and the public shouldn't tolerate this. The platforms, we see it's going on the platforms.
But they can't call the platforms and say, listen, we really think you should be taking this down because look at the problems that it's causing?
If it's protected speech, Your Honor, then I think we get closer. But, like, look, if you think that if that's clearly the way you're asking the question, I understand that the instinct that may not be a First Amendment issue. I guess what I fall back on, Your Honor, is that at least where the government itself, there is no emergency like this, there's nothing.
No, my hypothetical is there is an emergency. My hypothetical is that there is an emergency, and I guess I'm asking you, in that circumstance, can the government call the platforms and say, this information that you are putting up on your platform is creating a serious public health emergency. We are encouraging you to take it down.
I was with you right until that last comment, Your Honor. I think they absolutely can call and say, this is a problem, it's going rampant on your platforms, but the moment that the government tries to use its ability as the government and its stature as the government to pressure them to take it down, that is when you're interfering with third-party speech rights.
Well,
and remember,
Go ahead, finish your...
Your Honor, I was just going to say, even remember that the third party here is completely absent from the conversation. The third party whose speech is being targeted and ultimately censored is absent from this discussion.
Well, you don't. Do you think that simply Justice Jackson's hypothetical ended by saying we encourage you to take it down? Is that rise to the level of coercion that you think is problematic?
Your Honor, if the test is coercion and that's the test that this court applies, I think I might have a harder case saying that's coercion. I think it's, by its definition, it's maybe easier addressed as a substantial encouragement case. But if, whether you, as I said earlier, regardless of the label that you apply, whether it's coercion, whether it's encouragement, or joint participation in conspiracy, at the end of the day, if what the government is trying to do is to eliminate viewpoints from public discourse, that I think...
And again, under my colleague's hypothetical, it was not necessarily eliminate viewpoints. It was to eliminate instructions, let's say, about how to engage in some game that is seriously harming children around the country. And they say, we encourage you to stop that. I mean, that violates the Constitution?
Your Honor, I agree. As a policy matter, it might be great for the government to be able to do that, but the moment that the government identifies an entire category of content that it wishes to not be in the modern public sphere, that is a First Amendment problem.
Article 3.
Mr. Fletcher, let me follow up on that. If even one of the plaintiffs has standing, then we're required to get to the merits. So let me ask you about Ms. Hines. And as you just mentioned, she must have faced an imminent threat of future injury at the time when the complaint was filed, and that injury must be traceable to the actions of the government. So in the first part of that, imminent threat of future injury, her Facebook personal account was restricted at the time when the complaint was filed. So why isn't that sufficient to show an imminent threat of future injury?
We're not disputing that when the private platforms moderated the plaintiff's pages or their posts, that's an injury in some sense. We haven't disputed that. They suffered that injury. We've disputed the traceability question and then the redressability question.
Right. So on traceability is basically a question of causation, right?
Agreed.
All right. The district court found that the injury was traceable to the government's actions, and the Fifth Circuit accepted that finding, reviewed it, and accepted it. So that's two lower courts. We don't usually reverse findings of fact that have been endorsed by two lower courts, and you haven't attempted to show that it was clear that finding is clearly erroneous.
So respectfully, Justice Alito, I disagree with that. I think that the Fifth Circuit and the district court applied too loose a notion of traceability. They didn't try to say this post or any action against Ms. Hines was traceable to any action by the government. They did what the red brief calls a bird's eye view of traceability. They said the government is talking to the platforms a lot. The platforms are doing moderation. And so we'll just assume that all of that moderation is traceable to the government.
Well, do you think that it's necessary to identify a single government action and then trace it to a single consequence? Do you think that's required?
No, but I think you have to trace some government action to some consequence that befell you. And maybe I could just be specific about this, because we challenged this in our opening brief, and the red brief comes back at pages 19 to 21 and offers up what I take to be their best examples of traceable harm. And I invite you to go look at the pages of the record that they're citing, because often what you find is that they're citing moderation of their content that happened either before the challenged government actions to which they're referring or long after.
All right, I have looked at that. On the issue of causation, under Malhealthy, are they required to show anything more than the government's action was a motivating factor?
I don't know the answer to that in all cases, and I'm reluctant to make sort of broad statements about what the traceability requirement demands in different circumstances. I will say here, we're not disputing that. We're saying that they haven't shown any causal connection between the...
Has no effect whatsoever.
Right. And
both the lower courts were wrong on that.
I think they were, because, again, they did this blunderbuss approach where they said the government is talking to the platforms about moderation and the platforms are moderating content. But the platforms were moderating this content long before the government was talking to them. They had powerful business incentives to do the same thing. The acts of moderation were consistent with the platform's own policies. And this is, I think, another telling fact. In those red brief examples that we talked about on pages 19 to 21, some of them involve platforms like LinkedIn that wasn't even the subject of the challenged White House and Surgeon General's office communications with the platforms.
Thanks, Karine. Does the administration still have close contact with social media companies, and in specific, are there still communications about removing misinformation?
Look, I'm going to be, I know there's currently SCOTUS, well, I don't even know if it's happening right now, but there's this particular Missouri case. I'm going to be super mindful, super careful, and not to answer a question that is, adjacent to what's happening with this particular case. I don't have any conversations to speak to or to lay out to you about conversations with social media. Obviously, the president tries to communicate with Americans and meet them where they are. You see us do that pretty consistently. I just want to be super mindful as there's an ongoing case happening at this time.
Speaking about the particularities of the case, more broadly, can you talk about the administration's concerns on the kind of misinformation that's on social media?
We've been pretty consistent about the importance of, it is the responsibility of social media to make sure that what is on their platform is not misinformation, not disinformation. We've been always very clear about that. I just don't have conversations to lay out or to speak to, but we've been pretty consistent for at least the past couple of years on that.
Can you provide a definition for the word woman?
Can I provide a definition?
Mm-hmm.
No.
Yeah.
I can't.
You can't?
Not in
Okay.
this context.
So
I'm not a biologist.
The meaning of the